hearing today. I told you that we were going to hear 2447, but I received word last night from the governor's office that we don't need to hear that quite yet, so we're not going to. And that allows me to do something here at the very beginning as we work bills, if you guys are interested in entertaining this. Yesterday, I combined Senate Bill 60 and Senate Bill 204 because I needed a shell. I no longer need a shell. I know there was some concern about combining those two bills, and I have no desire to combine bills when somebody disagrees. When we have one bill that's widely supported and one that's not quite so supported, I don't want to combine the two to put people in a difficult spot. And so I did not turn in the committee report this morning and would make a motion to reconsider our action on Senate Bill 60 if there is a second. Second by Representative Hoheisel. Further discussion for me is my intent would be to pass out 60 by itself, and then we'd continue to have 204, which you could pass out by itself. And we'd have two standalone bills. So any discussion? Representative Heiberger.
Could you or Natalie briefly refresh us on the contents of each? The general.
Sure.
General.
Natalie, would you like to do that?
Yes, sorry, give me just 1 second. I was doing something here. So Senate Bill 60 is the bill that defines the proximate result for purposes of determining whether a crime was committed here or not. And then I didn't know if you wanted me to go ahead and do 204 now or wait a second.
Why don't you do them both?
Okay, and then 204 was the one that prohibited a court from ordering a psychological or psychiatric exam of a victim of a criminal offense.
Representative Keither.
Thank you, Mr. Chairman. I really appreciate what you are willing to do, and I certainly would favor doing them separately. Thank you.
Any further discussion? Not. I'll move my motion. All in favor, say aye. Aye. All opposed, say no. Motion carries. Okay, so now let's take up Senate Bill 60 all by itself. Are there any amendments? Oh, do I need an amendment? I haven't thought through this far. I do need an amendment. I'm not real happy with the effective date. So let's change that to publication in the Register. Is there a second? Second. Representative Carmichael with the second. Any discussion on the amendment? He's here in real life, all right? I know, scared me too. Okay, no discussion on the amendment. All in favor, say aye.
Aye.
All opposed, say no. Now, Senate Bill 60 as amended. It's a pleasure of the committee. Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out Senate Bill 60 favorably as amended.
Is there a second? Representative Hoheisel seconding is Representative Owens with the second. Any discussion? Representative Carmichael.
Thank you, Mr. Chairman. I continue to oppose SB 60 for the reasons previously stated, but I appreciate the chair's indulgence in splitting this because ultimately it will give both bills a better chance of passage. Thank you.
Not seeing any further discussion. Representative Hoheisel, you may close.
I close.
Heard the motion. All in favor, say aye. All opposed, say no.
No.
Motion carries. The affirmative votes, Owens, Hoheisel. The negative, and Neely. The negative votes, Carmichael, Heiberger, O'Hobson. Oh, that's really scary when I see Carmichael on my screen and next to me. It's two of them.
Mr. Chairman, I seldom confess this, but I am not carrying today, so you have no fears.
Okay, now let's take up Senate Bill 204 on its own. Natalie's already explained that a minute ago. We do need an amendment. So does anyone on the committee have an amendment? Seeing none, I would make the motion that we change the publication date to be effective upon publication in the Kansas Register. Is there a second? Representative Owens. Discussion? Representative Heiberger.
I just have a procedural question. Did not, it may be on the last bill, didn't we add the contents of 204 to 60? Or was it vice versa?
We added, yes, we added 204 to 60, which we then reconsidered.
Okay, but did we not then remove the contents of 204 from 60?
Oh. That's a good question. How would you like us to do that, Natalie? Did you hear the question?
Thank you, Mr. Chairman. I did hear the question. It's really up to you. I think as long as everyone on the committee understood that that last vote was to pass out Senate Bill 260 with the only amendment being the change to the effective date. You know, and so if you want to take some type of reaffirming vote or just make sure that that was everyone's understanding. And then now we're doing Senate Bill 204 with just the effective date change.
Got it. Okay. Does everybody understand what we did and they're okay with that? No objections to moving forward? Okay, so on 204, let's see, did I just make a motion? I did, I think, to change the effective date. And we had a second. All in favor of the amendment, say aye. Aye. All opposed, say no. Now, 204 is amended. Pleasure of the committee. Representative Heiberger.
Yes, I move that the committee recommend Senate Bill 204 as amended favorably for passage.
Is there a second? Representative Neely. Discussion? Representative Carmichael.
Thank you, Mr. Chairman. Ditto.
Any further discussion? Representative Heiberger, you may close.
I close and move my motion.
Heard the motion, all in favor say aye.
Aye.
All opposed say no. Motion carries. The yes votes, Owens, Hoheisel, Neely, Heiberger. The no votes, Carmichael, Wahhabism. Now that we're past 60, and reconsidering it and trying it all again, let's do 283. Natalie?
Thank you, Mr. Chairman. Senate Bill 283 extends a lot of the healthcare provisions related to COVID-19 that you guys put in place. You put in place during the special session, but then you extended them yet again this session in Senate Bill 14. This extends many of them out again to March 31st of 2022. And it also makes some changes to the healthcare immunity from liability provisions. And I can take any specific questions.
Any questions for Natalie? Are there amendments? Representative Ralph.
Thank you, Mr. Chair. I do have an amendment. Natalie, if you could distribute that, please. Mr. Chair, if I might go ahead, I think if I start an explanation, it might help on where these two balloons are jumping around.
Perfect.
As the committee might recall, when this was presented to us, the healthcare immunity provision was being asked and was intended to be extended for acts accruing through March 31, 2022. And that was being accomplished at page 4, line 4, in a provision D there that said the provisions of this section shall expire on March 31, 2022. This amendment will strike that line because adding that line would not have accomplished the expressed intention of extending that period of immunity, because we describe the actual period of immunity back on page 3, beginning at line 36, and the immunity was described there as existing from you'll see it there states apply to claims for damages, blah, 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 omissions occurring during any state of disaster emergency declared pursuant to the statute. So in that earlier section, we had already described when those claims would fall within an immunity period. So actually, in order to extend the immunity period, we needed to add the amended language you see in there in the balloon between March 12, 2020 and March 31, 2022. That would create the extension of the requested immunity period out to March of 2022, rather than the prior language in subsection D would not have accomplished anything in this regard. And then the balloon that you find at the bottom or toward the bottom of page 4, the larger one, just continues on to make that accomplishment in the language related to retroactivity, to make that also consistent with the fact that this immunity period for the healthcare providers would extend from the March 2020 date through and until March 31, 2022. Stand for any questions.
Any questions for Representative Ralph? Seeing any, would you like to move your amendment?
I move my amendment.
Is there a second? Representative Wheeler. Discussion on the amendment? Representative Carmichael?
Thank you, Mr. Chairman. The original bill was well and properly drafted. And as a matter of fact, it made to the extent you think the relief that this bill allegedly provides is worthy and necessary, it would be best to limit its effects to the period of time when there is an actual emergency and not expand this bill beyond the duration of that emergency. There's no reason for that type of legislative overreach, and I therefore oppose the amendment, although I understand why it's being made.
Further discussion? Representative Ralph, you may close.
I close.
Heard the motion, all in favor say aye.
Aye.
All opposed say no. No. Motion carries. That's good. Okay, further amendments to 283. Not seeing any. What's the pleasure of the committee on 283 as amended? Representative Owens.
Thank you, Mr. Chairman. I make a motion that we pass out Senate Bill 283 favorably for passage as amended.
Is there a second? Representative Hoheisel, discussion? Representative Carmichael.
Thank you, Mr. Chairman. As the committee will recall, when we heard this bill, I used extensive care in explaining my many concerns regarding this legislation. But in the interest of not being tedious, I will not repeat them here today, as I'm sure that those arguments are still yet fresh in everyone's mind. Thank you.
Any further comments? And online, Representative Owens, you may close.
11 goes tomorrow.
11? Holy cow, Annie.
Oh, that's better than some things. I've
Any
heard.
good ones?
I move we strike the representative's remarks from our record.
It is forever on YouTube. Sorry, Annie. I move my amendment, or move my motion, sorry.
You've heard the motion. All in favor say aye. All opposed say no. Motion carries. Affirmative votes. Owens, Hoheisel, Neely. Those voting against, Carmichael, Heiberger, Ohabisam. Let's move on to HCR 5014. Oh, yes.
With all due respect, I would like to request permission to change my vote on SB 104. That all happened really fast, and I just recalled the discussion we had in committee, which changed my mind on it, so I'd prefer to change my vote to a no if I can.
On 204?
Yes, the one we removed from 60.
Any objections, committee? If not, we will allow his vote to switch to a negative vote, correct?
Yes, thank you.
HCR 5014, Natalie.
Thank you, Mr. Chairman. House Concurrent Resolution 5014 would propose a constitutional amendment to the Kansas Constitution that would allow for legislative oversight of administrative rules and regulations. So any place in law where we grant rule and regulation authority, the legislature would be able to create a mechanism to either revoke that rule and regulation or suspend that rule and regulation. And I can take any questions.
Any questions for Natalie? Not see any. Are there any amendments? Don't see any there either. Is there a motion concerning HCR 5014? Representative Hoheisel?
Mr. Chair, I move we pass out HCR 5014
That's correct.
favorably for passage.
Is there a second? Representative Owens, discussion? Representative Heiberger?
Mr. Chair, I hate to overuse a phrase that we use a lot around here. It's not the T word, but I think this is a solution in search of a problem. I think there are some folks here who may not be real familiar with the rule and regulation process, so I just want to talk about that briefly. I mean, a state agency only has authority to write rules and regulations if we give them that authority, and only within the authority that we give them. And so if you look at any regulation, you'll see at the bottom, you'll see it'll cite an authorizing statute and an implementing statute. The authorizing statute is the one that says we give you the authority to write rules and regulations. The implementing statute is the one that the regulations are intended to implement, and those regulations have to be within the scope of whatever we've passed. You know, and the way a rule and regulation gets adopted is a pretty long and tedious process. I mean, first, the agency will seek input from stakeholders. They'll draft regulations that will go through review by the Attorney General, who can reject it if it's outside the scope of what their authority is. Goes through the Department of Administration, goes through the Department of Budget, thanks to a bill we passed a couple of years ago, goes through our committee on rules and regulations. And I think right before that is when there's a public hearing that any stakeholder, any person can provide testimony on. And often as a result of, I've been a hearing officer in quite a number of those hearings, often after the input is received, there will be changes proposed by the agency in the regulations. And if those regulations are substantive, then you have to start the whole process over again. It's not unusual for it to take a year. And so even at the end of that process, people still are aggrieved by the regulations sometimes, and they can take those, they can challenge them in court, and occasionally a court will find that the agency has either exceeded its the authority that has been granted, or that the rules didn't comply with what the legislature, what we said should be done. And if a reviewing court does that, there's still a chance for appeal. And if they were arbitrary and capricious in doing that, that ruling can be overturned by an appeals court. So what this resolution wants to do is to have, for this body, the legislature, after all that year-long or plus process has happened, it wants us to have the power to jump in and overturn the regulation without having to state a reason at all. I mean, I don't see that such a action would be subject to judicial review. So we could be arbitrary and capricious. And that just doesn't seem like an efficient or a reasonable way to do business. I think there are other ways to address this. One, and we already have the existing possibility of judicial review, which I think is used fairly often and to the success of the complaining party on quite frequently. And if we don't like the way our agencies are using the power that we delegate to them, then we need to be more careful. We could be more careful about how we delegate our power. We could put more restrictions on the rulemaking authority, or we can put more detail into the statutes that we adopt. But one of the reasons we do rules and regulations in the first place is that this body doesn't have the time or the expertise to get into all the technical details of some of the areas that are being regulated by our state agencies. And so, again, I think there's existing mechanisms for dealing with this problem to the extent that there is a problem. And so I would encourage you to turn this down. And if any, I mean, in my entire time in this legislature, I don't think I've heard anybody object to the granting of rules and regulation authority to a state agency. I mean, if that's the problem, then that's where we should be addressing it, I think. So thank you for your time, buddy, colleagues.
Thank you for that background, Representative Heiberger. I had forgotten that I think Representative Humphreys asked that we have some background information, and I know Natalie was prepared to do that. Is there anything additional you'd like to add, Natalie?
No, Mr. Chairman, I think Representative Heiberger pretty accurately described the process. If any committee member does have a question about the process or the legislative role in that process, I'd be happy to take any specific questions.
Any questions about that, committee? Again, thank you, Representative Heiberger, for catching my failure to ask Natalie to give us that overview. Representative Keither.
Thank you, Mr. Chairman. Actually, it was I who requested Natalie's oversight of the process because not everybody has a chance to be on rules and regulations. I happen to be on it now and have been for several years, as has Representative Carmichael. And we certainly have had some feisty discussions in that committee, that's for sure. I think this is a totally unnecessary bill. I think what we have in place is very well put together, as Representative Heiberger did a great job of explaining. It has a rigorous process to go through. And as the body of the legislature exists, no, I don't, in all the years I've been here, I too don't remember too many people having a robust discussion about rules and regulations in any agency. So for us now to be saying that this is our job and for us to have the oversight, I think it's the wrong way to go. And I think what we are doing is the proper mechanism. And I certainly am not going to be supporting this resolution. Thank you, Mr. Chairman.
Further discussion? Representative Owens?
So there's a lot that comes to mind as we have this conversation. Because over the last 9 months, I believe we have had a significant problem that exists within the Kansas Department of Labor. And I think that if we were to do some kind of an open records request of all of our emails, we would see just how vast that problem is. And the fact that the legislature's hands have been absolutely tied in being able to effectively, well, do anything within that agency is been one of the biggest frustrations of this session and of this last year. So with that in mind, I'm truly very glad I'm not on the Rules and Regs Committee. That seems like an absolutely enormous amount of work. However, I've got to believe in some ways it's kind of like legislation, that you put your best foot forward, you make your absolute best effort, you try to vet it as much as possible, but even sometimes it's still not right. And there still has got to be legislative checks and balances in that process. And so just a couple of comments, and with that, I certainly stand in support of HCR 5014.
Representative Heiberger.
Thank you, Mr. Chair. And Representative Owens, I certainly share your concerns about the difficulties we've had with the Department of Labor over the last 6 months. I'm very frustrated also, but I don't see how your concerns have anything to do with their rules and regulations, or how adopting this would change any of that, change our authority to deal. And this is about rules and regulations, and the problem there I don't see has anything to do with rules and regulations.
Further discussion?
May I?
Representative Owens?
Thank you. Well, and I would love to say that I had the absolute for sure that I did or didn't know that, but the reality is I know that I don't even have the opportunity to review their rules and regulations to know whether there is anything that could have been changed to make that efficient more process, or that process more efficient. Because even if I did review them, I would have zero authority to actually change them or to force any change from that perspective. So it made no sense for me to even go down that path. So thank you.
Representative Heiberger.
Well, I guess I would disagree with that. One, I mean, the regulations are all published. And if you could identify regulations that were contributing to this problem, you could bring a new statute that would change. We could change our statutes, and if we change our statutes to the effect that existing regulations conflict with them, then they would no longer be enforceable, and they'd have to go through the process of redrafting the regulations, assuming, of course, we left them with still having that authority.
Representative Carmichael.
Thank you, Mr. Chairman. I know it's hard for the committee to believe, but I had intended to sit here quietly on this one. I have been privileged to serve on that committee now for, I think, roughly the past 6 years, at least 2 or 3 of those as the ranking member. We rotate the chairmanship or chairwomanship and the ranking member position between the House and the Senate. As Representative Keither says, I think she is the senior serving member on the Rules and Regs. I believe Representative Burris is on with us this year. No? Okay, well, I apologize. We'd like to have some more lawyers on there, so I hope you'll speak up to your leadership because we could use your help. But seriously, there are real problems, I agree, with administrative agencies, be they under Democratic governors or Republican governors who like to build. I think I complimented one of them the other day on the floor about being the most successful bureaucrat in the state. And that particular bureaucrat was appointed by Sam Brownback. And then he was reappointed by Laura Kelly. And I'm aware of the speech and debate clause. He hasn't changed his ways, okay? Doesn't matter who appointed him. He still loves to write rules and regulations that, in my judgment, are burdensome. And there's another problem, and that is that a lot of these rules and regulations do not come from cabinet-level agencies. They come from the independent boards and commissions. Oftentimes, their membership is made up roughly half of legacy appointments from the prior governor, and then new appointments from the current governor. It's a good idea to do that with these independent boards, and that's a discussion for another day. But they have independent rulemaking authority, separate and apart. There's no oversight by the governor in those circumstances. It's only the cabinet level agencies where the governor could, and even then, Wildlife and Parks may be an exception, but even then, the governor can't do anything about what they send us. It has been my observation that Rules and Regs is one of the most bipartisan committees in this legislature because all of us are equally offended. And it generates unity and cooperation. But I've also observed that when a member of the legislature decides to run for governor, be he a Democrat or be he a Republican, they oftentimes start to change their views about legislation such as this. And I suppose that is to be expected because it will cut both ways. One way or another, one party will feel victimized by the regs and we'll go down the road. We have worked actually in the committee to do some things short of what is being proposed here, and actually which I think would be more efficacious in accomplishing the proponent's purpose. And I've discussed that at some length. In fact, we had a meeting with the current chair of the committee. I think the vice chair was with us. I know people from the revisor's office to discuss some legislative solutions to this problem short of a constitutional amendment. I don't necessarily support all those solutions, but let me give you some examples of things that we could do with a scalpel rather than an axe. One of those things is currently any member who is aggrieved by any regulation, be it one that has just been adopted or be it one that's 20 or 30 years old, like, by the way, a vast number of the Department of Labor's regulations go back to the 1980s. And if a member doesn't like that reg, you can introduce a bill. I introduced a bill concerning whether or not it's sportsmanlike or safe to hunt at night by night observation devices. The Wildlife and Parks Commission, they think that that's sportsmanlike, and the that ought to be okay. So they passed a reg. I didn't like it. I introduced a bill, and it's lying around in some committee somewhere. Okay. But if it had merit, I'm sure that the chair of that committee and the majority leader and the speaker would bring it immediately to the floor and we'd put them in their place. But people judged my bill didn't have that much merit. That's the first thing. Second thing, when we pass rules and regulations, we need to strictly limit the discretionary authority of the agency. If you do that in the first instance, then you take care of the problem. A third thing that we could do is, and it may even be internally through committee rules, if not a statute would fix it, and that is to say that the agency cannot hold their public hearing, which is required before they can promulgate and adopt. They can promulgate, but they can't adopt a regulation until they've had a public hearing. And right now, the law says that the Rules and Regulations Committee that will meet and that will provide recommendations prior to that public hearing. And quite frankly, sometimes the agency wags the tail of the dog. And if I were the chair, I'd tell them you'll wait till we have the next meeting rather than accommodating them, but we accommodate them. But we could change those rules so that the agency can't hold a public hearing until they've received the legislative comments. And the legislature can ponder for a long time before they get around to commenting on something that they don't like. That would reel them back a little bit. Another alternative that we might employ, and in fact has been employed, when the agency head comes to the legislature requesting budgetary authority, provisos can be added to the budget that says you don't have a dime to enforce this regulation that we don't like. When agency heads treat legislators rudely regarding rules and regulations, there's a budgetary consequence. And in fact, there's a Democratic senator that will tell you a story about what happened to him when he tried to snub his nose as an agency head at the rules and regulations process. He found less money the next year. Additionally, we can fix these problems a lot quicker through a simple bill process than we can going through a revocation process as is contemplated by this proposed constitutional amendment. And, you know, we can run simple bills to proscribe the agency's rulemaking authority. We can repeal their regulations. We can do all kinds of things short of striking of the entire regulation. If you strike an entire regulation, then you're left with no regulation. And that creates another problem. And that is agency heads that they may not like a statute, so they just never promulgate the regulations that would implement the statute. And I can show you multiple instances of that too. The cure for the problem is for all of us to sit down and work together as legislators and come up with a bipartisan solution that will survive the Kelly administration. It will survive perhaps a Schmidt administration, certainly survive a Carmichael administration because I'm not running. But, you know, we could do this and we could do it better through legislation than asking the voters to go vote about rules and regulations. They'd have absolutely no idea what they're doing. So I can go on, but I hope you understand my point is that as valuable as this idea is, and I absolutely agree with the chamber on some of these issues, this isn't necessarily the best way to do it. If we can't fix it legislatively, then let's come back. Final remark is the situation of the Department of Labor isn't because of rules and regulations. To the best of my memory, we haven't seen anyone from Department of Labor since the Brownback or Collier administration. So if there are rules and regulations that have caused the problem over at DOL, number one, it wasn't the present governor because she hasn't sent us any rules and regulations, or actually the secretary. And number two, we can revoke those old rotten regulations from the 80s at DOL. All you got to do is look in the book and run a bill across the floor. So I appreciate your indulgence. I hope that we will move slowly. I hope that we'll let this just lay below the line. Let's try some other solutions. And if we have to get out the constitutional acts, then we can go see if the voters even understand what they're voting about. Thank you, Mr. Chair.
Representative Schreiber, then Heiberger.
Thank you, Mr. Chairman. This question is probably for Natalie, but I just wanted to be clear on when it says provides the legislature with oversight of state executive branch agencies and officials. Would that include those commissions or groups where there are appointments made by the governor, such as the KCC?
Mr. Chairman, and if you look on page 1, starting at line 15, so we say whenever the legislature by law has authorized any officer or agency within the executive branch to adopt rules and regulations. So the KCC is an entity where you have statutes that give them rule and reg authority. The KCC does have rule and reg authority. So any of those groups, we tend to think of the cabinet level, like the Department of Health and Environment, but all those small boards, commissions, the cosmetology board, the barbering board, they all have rule and reg authority. So this would apply to those as well.
Okay, thank you. Thank you.
Representative Heiberger.
Thank you. I'll be very brief. One thing I forgot to say is that under our system of government, the legislature has authority to set policy and the executive has the duty to implement policy. And courts have found things like this to be a separation of powers problem because we're getting into the implementation. And I think it's a poor way to respond to a separation of powers problem by enshrining it in our Constitution.
Further discussion? Seeing none, Representative Hoheisel.
Thank you, Mr. Chair. I close.
For the motion, all in favor say aye. All opposed say no.
No.
Motion carries. Division's been called. All those in favor, raise your hand, please. Seven in favor. Those opposed? 4, 5, 6. It's getting confusing counting some of you twice because I see you on the screen and in person, but. So, motion did carry. Yeah, right? And he leans into my screen, so I count him 3 times. Motion carries. So those wanting their affirmative votes recorded, Owens, Hoheisel, Burris,
Christ, they know
Neely.
not what they do.
Annie, you're not muted again.
Well, it said it was on my screen, so whatever you heard, I didn't say.
Okay, perfect.
Who are you going to believe, me or your own lying eyes?
I could barely hear it. I'm going to have to go home and listen tonight. The no votes, Carmichael, Heiberger, Ohabism. Okay, thank you. Now we're on Senate Bill 122. Back to Natalie.
Thank you, Mr. Chairman. Senate Bill 122 is the bill that you heard yesterday with Professor Kincannon. It modifies certain rules of evidence in the Code of Civil Procedure related to the authentication of records and documents.
Any questions for Natalie? Are there any amendments? It does need one. I would make a motion to change the effective date to publication in the Register. Is there a second? Second by Representative Hoheisel. Discussion on the amendment. Seeing none, all in favor say aye. All opposed say no. Motion carries. On the bill, is there no further amendments? Is there what would the committee like to do? Representative Hoheisel.
Thank you, Mr. Chair. I move we pass out SB 122 favorably as amended.
Is there a second? Representative Humphreys. Any discussion? Not seeing any. Representative Hoheisel, you may close.
Thank you, Mr. Chair. I close.
For the motion, all in favor say aye. All opposed say no. Motion carries. Yes, affirmative votes. Owens, Hoheisel, Carmichael, Heiberger, Ohabism. And I don't believe there are any no votes. Committee, the next bill on my list is 2412. And here's what I'm going to do. We're coming back tomorrow to work or to hear and potentially work 2451. So I'll remind you about that before we adjourn. So since we have to come back, what I'm going to do, Natalie, would you go ahead and distribute the amendment that I contemplate that intend to offer tomorrow? And so I want you all to have the evening to look over it. I did get some, we have been working with, and actually they've been working together to address the concerns of one of the neutrals, the Kansas Association of Addiction Professionals, the AG, the league. I've heard from the Association of Counties. We've also addressed some concerns of counties. And so this balloon doesn't address everyone's concerns. I certainly don't want to say that, but they have worked hard to come up with something that gets close to addressing many of the concerns. I did get some information from the opponent with some suggestions, and unfortunately, it's formatted so that I can't. It's not opening, so I don't know what their concerns for sure are. But I want to have the opportunity for them to get that to me, see if there's anything we can continue to address tomorrow. When you see this, you'll see that the big change is instead of having just the Kansas Fights Addiction Fund, there'll be two funds. 75% of the money will go into that Kansas Fights Addiction Fund, and then 25% will go into a fund for municipalities. You'll see the details when you get it. Encourage you to look through it. There are some other changes in the balloon. Take a look at that this evening. It very well may change before I offer it tomorrow based upon feedback, but I want you to at least see where we're at now, and we'll add that, have that first up tomorrow. The bill number 2412. Representative Carmichael.
Thank you, Mr. Chairman. I appreciate the chair's courtesy in handling it that way. I think it will be much better use of our time if we can study it overnight. I presume it will be posted as a miscellaneous document of some type so as to comply with KORA.
It's been distributed to the distribution list, so everybody who signs up to get stuff just got it.
Okay, I just want to make sure that we don't violate KORA, and I'm not sure whether it has to be posted on the website or not. Doesn't matter. I'll leave that to smarter heads. But I would also appreciate then the courtesy of allowing the reviser to similarly release my amendments, because I think in the end it will save us some time tomorrow. And specifically, it's an amendment striking section 6 of the bill, and I believe there's a second balloon amendment that limits the application of the act to cities and counties with populations in excess of 250,000. And then there's a third amendment that is conceptual. We don't need to release it, but it would be to add HB 2365, the opioid 911 Good Samaritan bill that sadly we were unable to get to on general orders. So just so folks know where we're going, and that way everyone can be prepared for a robust debate.
Very good. I appreciate that.
Thank you.
So that we'll have that one tomorrow, and then Senate Bill 273. That was the Senate's KEMA bill. I put that on the list for today, thinking we may have needed it for the bill that we were going to hear today. I just want that on the list of bills we may work tomorrow. We will be hearing tomorrow House Bill 2451. I know I wasted some of your evening last night asking you to review 2447, but for tonight, I'd encourage you to review 2451, which is what we will hear tomorrow. Obviously, we all know that this is the last week to work bills, and so we'll hear it tomorrow. Take a look at it. Come with good questions and concerns, and we'll see if we get in a position where we could work it tomorrow and put it in that Senate bill. That would be great. If not, there's always Friday. That's not a threat. Just letting you know that Friday is our deadline, and we'll see where we end up tomorrow. I don't want to rush anything, and this feels like we're rushing, but I want to make sure we get it right too. So it's for tomorrow, 2412 and 273, which my intent would be, if we work it, to put in the contents of 2451. Any questions, Representative Humphreys?
Thank you, Mr. Chairman. Your amendment that we got on 2412, just so as I'm reading it, I'm understanding where it's coming from. Remind me, was that something that one of the neutrals or somebody asked for, or kind of where did that come from?
So that came from a conversation with a number of the conferees. And one minor change came from the Kansas Association of Addiction Professionals, and that was just they wanted to make sure that there were addiction professionals, so we struck some language or made that clear. The two separate funds, that came from in conversations with the Attorney General, with the league, with a representative of a county. And then I have since heard from the Kansas Association of Counties that they also support that. So those would be the
That's
parties.
helpful as we look at it.
Yeah, those would be the parties that were involved. I'm not forgetting anyone, right?
Okay, thank you.
Representative Heiberger.
Yes, Mr. Chairman. Just for the record, your previous comment did sound like a threat.
So I know, well, as soon as it came out of my mouth, I knew it did sound like a threat. So I didn't mean it that way. We'll see what happens. So that's it for today. I appreciate everyone's work. We will get off early. We'll see you all tomorrow. Thank you.